You're fired. You're fired. You're fired. You're fired.
For someone famous for saying you're fired, Donald Trump can't say it to many people in the executive branch, and that's a constitutional problem. Under a 1935 case called Humphrey's Executor, presidents have a limited ability to fire executive officials at independent agencies. That issue is now front and center in the case Trump versus Slaughter, and the Supreme Court will hear arguments on December 8th. Trump fired FTC Commissioner Rebecca Slaughter in March of this year. She sued, citing the precedent set by Humphrey's Executor. The case has already been heard by the District Court for the District of Columbia and the U.S. Court of Appeals for the District of Columbia. So why is this important? Agency officials wield enormous power over American jobs, businesses, and money, yet they're insulated from executive accountability because of a deeply flawed, nearly century-old decision. At NCLA, we're not proponents of unchecked executive power, but in this case, the question is whether our president or any future president can run the executive branch as they see fit and be able to appoint and fire agency officials. When powerful regulators can't be fired, they stop answering to the Constitution. That's why Trump versus Slaughter is so important, and why NCLA filed an amicus brief in which we write that the text, structure, and historical context of Article 2 establish that the president, as the sole head of the executive branch, holds an absolute and unqualified removal authority over officials exercising executive power. Simply put, if you exercise executive power, you should be fireable by the executive.